This is Sobia from Law Info. Labor law in India. The contract labor law regulates the employment of contract labor in certain establishment and provides for its abolition in certain circumstances. The Contract Labor Act prohibits the employment of contract labor on jobs they are perennial in the nature. For such job, permanent employees need to be employed. Indian labor law refers to law regulate labor in India. Traditionally, Indian government as federal and state level have sought to ensure the high degree of protection for their workers. But in practical, this differs due to the form of government and because labor is a subject in the concurrent list of Indian Constitution. Constitutional right. In the Constitution of India from 1950, Articles 14, 16, 91C, 23 to 24, 38 and 41 to 43A directly concern labor rights. Article 14 states everyone should be equal before the law. Article 15 specially says the state should not discriminate against their citizen, and Article 16 extends a right of equality of opportunity for employment and appointment under the state. Article 91C gives everyone a specific right to form association or unions. Article 43 prohibits all trafficking and forced labor, while Article 44 prohibits child labor under 14 years old in a factory, mine or any other hazardous employment. Article 38 to 39 and 41 to 43A. However, like all the rights listed in Part 4 of the Constitution are enforceable by law, rather than creating an aspiration duty of the state to apply this principle in making laws. The original justification for leaving such principle unenforceable by the courts was the democratically accountable institution ought to be left with discretion. Given the demand, they could create a state for funding the general taxation, although such wish has since become controversial. Article 31A says that in a general, the state should strive to promote the welfare of the people with a social order in which justice, social, economic, and political shall inform all the institutions of the national life. In Article 38.2, it goes on to state the minimize the inequalities in income and based on all the other statutes. Article 41 creates a right to work, which is the National Rural Employment Guarantee Act 2005 attempts to put into a practical. Article 42 requires the state to make a provision for securing just and human condition of the work and for the maternity relief. Article 43 says workers should have the right to a living wage and condition of work, ensuring a decent standard of life. Article 43A, inserted by the 42nd Amendment of the Constitution of India in 1976, creates a constitutional right to condetermination by the requiring the state to legislate to secure the participation of the workers in the management of undertaking. Contracts and rights, scope of protection. Indian labor laws take a distinction between the people who are organized sector and people who are unorganized sector. The law listed the editor to which various labor rights apply. People do not fall within this sector. The ordinary law of contract applies. India's labor law underwent a major update in the Industrial Dispute Act of 1947. Since then, an additional 45 national laws expand or inserted with the 1948 Act, and another 200 state laws control the relationship between workers and the companies. Employment contracts. Among the employment contracts, there are regulated in India. The regulation involves significant government involvement, which is rare in the development countries. The Industrial Employment Standing Orders Act 1946 requires that the employers have terms including working hours, leave, productivity goals, dismissal procedure, or work classification approved by the government body. The Contract Labor Regulation and Abolition Act 1940 aims at the regulation employment of the contract labor so as to the place it at the part of the labor employment directly. Women are now permitted to work night shift too, 10 p.m. to 6 a.m. Wages Regulation Act. The Payment of Wages Act 1936 requires that the employees receive wages on time and without any unauthorized deductions. Section 6 requires that the people are paid in money rather than in kind. The law also provides the tax withholding the employers must deduct and pay to the central or the state government before disturbing the wages. The Minimum Wages Act 1948 set the wages for the different economic sector that this stated will cover. It leaves a large number of workers unregulated. Central and state government have discretion to set wages according to the kind of the work and location, and they range between as much as 143 to 1120 per day for the work in the so-called central space. The state government have their own minimum wages schedule. The Payment of Gratuity Act 1947 applies to establishment with the 10 or more workers. Gratuity is payable to the employee if he or she resign or retired. The Indian government mandates that this payment be at the rate of 15 days salary of the employee for each completed year of service, subject to a maximum sum rupees. The Payment of the Bonus Act 1965, which applies only to enterprise with over 20 people, require bonus are paid out the profit based on the productivity. The minimal bonus is currently 8.33% of the salary. Weekly Holidays Act 1942, BDN Cigar Workers Act 1967, Health and Safety. The Workman Compensation Act 1923 requires the compensation is paid if the workers are injured in the course of the employment for injuries or benefit to dependent. The rates are low. The Factory Act 1948 consolidated the existing factory safety laws. The Sexual Harassment of Women at the Workplace Prevention, Prohibition and Redressal Act 2013 that seeks to protect and provide the mechanism for the woman to report incident of sexual harassment at their place work. Pension and Insurance. The Employees Provident Fund Miscellaneous Provision Act 1952 created the Employees Provident Fund Organization of India. This functions as a pension fund for the old age security for the organized workforce sector. For these workers, it creates provident fund to which employer and employers contribute equally, and the minimum contribution are 10 to 12% of wages. On retirement, employees may draw their pension. Indira Gandhi National Old Age Pension Scheme, National Pension Scheme, Public Provident Fund. The Employees State Insurance provides health and social security insurance. This was created by the Employees State Insurance Act. The Unorganized Workers Social Security Act 2008 was passed to extend of coverage of life, disability benefit, health and maternity benefit and old age protection for unorganized workers. The Maternity Benefit Act 1961 creates the right to the payments of maternity benefit for any woman employee who worked in establishment for the period of at least 80 days during the 12 months immediately preceding the date of her expectation delivery. On March 30, 2007, the President of India, Pranab Mukherjee, approved the Maternity Benefit Amendment Act 2007, which provides for the 26-week paid maternity leave for women employees. The Employees Provident Fund and Miscellaneous Provision Act 1952 provides a compulsory contribution funds for the future of employee after his or her retirement or his or her dependent in case of employee's early death. It extends to the whole India. State laws. Each state in India may have special labor regulation in certain circumstances. Every state in India makes its own regulation for the Central Act. The regulation may vastly differ from the state to state. The form and the procedure used will be different in each state. The central government is in the process on simplifying this multiple state law into 4 labor codes. They are Code on Wages, Number 2, social security and welfare. Number 3, industrial relations. Number 4, occupational safety and the health and working conditions. Thank you.